We are recording.
Welcome, everyone. This is our June 15th meeting of the CSBARS. At this time, can we please call roll?
All right. Dean Clancy,
Present.
Keller,
Present.
Kramer, Murphy, Park. There she is. And Leo.
Here, present.
All right, we have quorum.
Thank you.
Sorry if I got missed. I was just transitioning to panelist, but if my name was called, I am present.
As I am as well. Thank you. So perfect timing, actually. Next, this is a time for public comment. If there's any members of the public wishing to make public comment, you can express your interest by raising your hand virtually on your computer or by using the *9 function on your phone if you're calling in to raise or lower your hand. You'll be recognized in the order raised by your hand and will be recognized for a period of 2 minutes. Additionally, you can have further public comment in writing. And if you'd like to, please email it to Ms. Leonard at lawschoolregulation@calbar.cal.gov. At this time, do we have any public comment?
There are no hands at this time, no public comment. And just a reminder that public comment can also be submitted in writing to those addresses prior to the meeting as well. Thank you.
So hearing no public comment, let's move on to our agendized items. Our next item is our minutes. Does everyone have an opportunity to review the minutes as posted to the CSBARS on our website? And if not, would anyone like additional time to review those minutes now? Not hearing any. Request for additional time. Is there a motion to adopt as written or a discussion to correct any proposed errors or omissions within those minutes?
Move to approve.
Second.
Can we have a roll call vote to adopt the minutes as presented?
Yes. Brickberg,
Aye.
Clancy,
Aye.
Keller,
Aye.
Kramer, Murphy, Park,
Aye.
and Leo.
Aye.
Excellent. Our minutes have been adopted. Next, we have staff report. I believe our first itemized area is with Ms. Nunez on our provisional licensure program update.
All right, thank you. I believe we have a PowerPoint that we're going to put up. All right, next slide, please. All right, well, as many of you know, on May 26th, the California Supreme Court issued an order to extend the original program. And it was extended for both the 2020 law school graduates, as well as those that were qualified under, based on a bar exam score for between February 2015 and December 2020. And this extension goes through December 31st, 2022. The court recognizes the contributions that PLLs are making in their chosen fields, and this timeline extension provides additional time for PLLs to meet their requirements for full licensure, and also ensures a seamless transition from provisional to full licensure. The order itself does not change the program eligibility requirements, nor the requirements for full licensure. So applicants are still required to meet the educational requirements. For example, if they have not passed the MPRE They were required to complete the 4 hours of professional ethics of the 10 hours of new attorney training. And they were required to do that in the first 30 days of coming into the as a PLL. And applicants are also all required to complete the 10 hours of new attorney training within the first year of participation as a PLL. And failure to do either one of those can lead to termination, even in the extension period. Also, applicants in the expanded pathway need to continue tracking and submitting their time logs with the extension. Time logs are still required from their supervisors, as well as positive evaluations. The extended timeline also allows more time for applicants to meet any outstanding licensing requirements, such as passing the MPRE, which you just mentioned, and that requires a score of 86 and above. Also, obtaining a positive moral character determination that is required for full licensure versus needing to have just submitted an application was one of the requirements for the PLL program. And then obviously for 2020 law school graduates, there's a requirement of passing the bar. So as of June 10th, this is the remaining cohort. These are actively practicing PLLs, consist of 215 from the original program, meaning those that qualified based on graduation date, and 147 in the expanded pathway. Next slide, please. Okay, so here are our statistics. As you can see here, I already mentioned them. We have about 362 active provisionally licensed lawyers as of June 10th. Approximately, as you can see here, 1,112 participants have been admitted to the bar. And it's spelled out in that admitted to the bar line. And it's distinguished between both groups. So 616 of these PLLs sat and passed the bar exam, while the remaining 496 that are in the expanded program, they were licensed when they worked over 300 hours and received positive evaluations from their employers. As for the other items here, the remaining cohort includes 12 people that are currently suspended and 99 terminations. And terminations and suspensions happen for a variety of reasons. Terminations happen when somebody moves from one position to another, their job ends, or there are some program violations. Altogether, about 1,585 applicants have participated in the provisionally licensed lawyers program. Next slide, please. Here are the demographics of the group that has been admitted to the bar. This is under the license pathway. As you can see here, and hopefully you can, because that font is looking small to me right now. But here, the largest category of applicants are white that have been admitted to the bar via the pathway, and followed by Asian and Hispanic. Next slide, please. As for the law school types, as you can see here, 178 of these applicants are from California ABA law schools, and 137 from CBE accredited law schools. The next category is other, which includes our out-of-state attorneys. Next slide. And another demographic breakdown, we looked at gender. So as you can see here, the largest proportion of PLLs that have been licensed via the pathway are female, 269. And that's a quick overview of the program now. And also I'll open it up in the event that anybody has any questions. Okay.
Got it off mute now.
Okay.
Sorry for the delay. I have a question, and it's about the difference between the numbers we saw for race in ethnicity in the way of a breakdown compared to what it usually is on the bar examination. I'm just wondering if there's an increase for any particular race or races through this program.
Yes, I could bring that to our next meeting. The February 2021, I'm sorry, February 2022 general statistics just went up to our bar website today. So I could definitely bring that back to the next CSBARS meeting to make that comparison. That is the same demographic, law school, and race ethnicity comparison compared to PLL's license in the pathway. Dean Clancy, I'll bring that to the next meeting.
Thank you very much.
Sure. Dean Park. Uh-oh, I think we should, oh, there we go.
Yes, I was just looking at the breakdown among schools, and I really appreciate the other demographics as well. So it definitely seems that the majority of participants are at the ABA level, followed by Cal Accredited. And then I saw 18 from the unaccredited law school group. But I think it was kind of quick. Was there also an ABA outside of California category there?
Yes, there was. There are 71 in that category. I can also provide this a PowerPoint to the CSBARS after this meeting.
Oh, great. But so that's about 240 ABA law school students that participated then. And then
Yeah.
California accredited is 137. Thank you.
Sure. All right. I will give it back to you, Natalie. Thank you.
Okay, thank you. So our next item, number 3, regarding multiple choice, will be special set at 2:40 because we'll be bringing outside guests, the psychometric team working on that project. So with your permission, Chair Frickberg, we'll move to the next item.
Definitely. I don't think we touched on item number 2. Is that still on the agenda? The
Oh, I
PL.
apologize. Yes. Yes. So that one is related to the NPR. We are in the season when accredited law schools report their NPR by July 1st. Due to the addition of the PLP program, that reporting is now a 2-step process, and we wanted to give an opportunity to review the process and allow any members to ask any questions they have to enhance the ability to forward timely materials. So at this point, each accredited law school should have received a 3-part application. The first is an instruction sheet. The second is a preliminary reporting sheet. And then the third is an Excel spreadsheet. And it's the Excel spreadsheet where I want to focus time. And I'll just share my screen as to that so that we can take a look at it. And it's opening up on my screen. It will be just a quick moment. Okay, can everyone see my Excel screen? Thank you. Okay, so we've made some changes this year based on feedback from CSBARS. The first is to more clearly note that when the schools are providing information without the PLP updates, that this is a preliminary component. This is not an NPR or an estimated NPR. The NPR will be revealed later. And this way, if any document were reviewed on its own out of context, anyone would know that this was not a final NPR for any school. And any PLP adjustment should only increase any school's NPR rather than negatively change it in any way. Some people ask questions about this Excel spreadsheet and this format, and so that's why I wanted to bring it up here. Each time that we do the MPR process, I think schools become more and more familiar with it, but it is a little bit of a challenging process. The things that make it challenging are also things that make it fair and helpful and informative to the schools. And so we work to balance, and as a result, the State Bar verifies the filing in a collaborative manner with the schools each time. We ask for this format so that each school will provide in a similar way. It makes it much easier for the State Bar to do quality control and to get the PLP adjustments back to you timely. We will complete your full validation before we do the PLP adjustments. And some of the elements here are very, very necessary. For example, we have a first name, a middle name, 1, 2, and a last name. Many US names do not have a second middle name, but we include both fields because we do have a fair number of students that will use both, and it allows us to do better sorting that way. Also, a column that we added last year that was extremely helpful was other name used by the graduate. We do see a lot of name changes, and sometimes your law school may know about them, other times not. It may have happened since they graduated. But if you do know and you can provide that information, that can be a very large help to us. Common reasons could be a gender change, a divorce, a marriage, or just simply a decision to change. So we will ask that you use this format, and submissions that do not use this format, unfortunately, will need to be returned. I wonder if the group has any questions, or if any groups would have any tips in particular for using the format. And not to put anybody on the spot, but I might ask Dean Keller, only because you've got a very large cohort at your school. And so you may have some tips that could help others, because your school always does a great job.
Well, thank you. My tip is to have colleagues who do most of it for the first draft, so that you just have to review it and make sure it's been validated. So we didn't have any problems. We've been doing this in a similar fashion, and occasionally we do have information on that other name used by the graduate, but we didn't have any issues. Didn't really. I appreciate the additional language, but it was pretty much par for the course with the last time around for us.
Thank you. That's good to hear. Dean Frickberg?
Just to mention, as a smaller school, I do all the data myself as we go through, and it's my favorite acronym is garbage in, garbage out. GIGO as you go through. So I think that so much of it is just making sure your data is accurate. At least as I go back and forth with the staff on the committee, it's sometimes an error and input on my side just to adjust, especially when we're looking at the dates for graduation. As an example, our dates will change because it's month, day, and year. So I can't just copy and paste that same field over and over year after year. Unfortunately, I can't do that. And I think that the multiple names is very helpful, because that's usually where most of the back and forth with staff historically was with me, because we'd have their name when they were a student, and I didn't know that the name changed after they left our institution, as an example. So I think that's a very helpful field.
Good. And I really appreciated the collaboration with the schools when we ask for this. This is a call that we'll make to every single school. We're really just double checking, and it helps us to keep our records as clean as yours would be also, Dean Frickberg, as you described. So I wanted to thank the members here, but also the deans and schools that are watching in the audience as well. Okay, any other questions related to MPR? Okay, so I encourage everyone to report their materials timely by July 1st at 5. To the extent you have them ready earlier, please do feel free to send them. The earlier you send, the earlier we can begin to validate and provide your PLP adjustments. And then the MPR values will be presented to the committee at their notice meeting in August. Thank you. Okay, the next items in the staff report all relate to participation. These are opportunities for your school to participate or to shape agendas. And so we look forward to your engagement and your feedback on these topics. The first one relates to, I'm going to share my screen for this, relates to applying to be on CSBARS. So if you would like to join the team here, we encourage you to do so. We are so committed to this that we actually have the latest deadline for all of the committees for application, which is July 1st. So there is still time to apply to be on the CSBARS for next year if you think that you may be interested. Up on our State Bar website, you have a committee page for State Bar accredited and registered schools. The application is there. The reminder of the date is there. And you can see a little bit about the current members and the composition of the committee. And while we're on this page, if it is not the moment for you to serve on CSBARS, I also want to remind you why this page is helpful. It can tell you about the schedule that's coming up. You can access materials about prior meetings, see prior agendas, and at the bottom of the page, you can also subscribe to updates as to CSBARS. So when the agenda is posted or other materials are added, you'll get an automatic e-blast letting you know that this is here. You can come to the web page and access those materials prior to the meeting. If you'd like to submit a public comment after reading them, you can do so as well. I know that probably many of the members of the audience have already done so, but just a reminder that that information is there. Any questions about the CSBARS application process or that page? Okay. Seeing none, we can move on to the next, which would be topics for the Fall Law School Assembly. And I'm going to share my screen again. Just a moment. Okay, is everyone able to see the PowerPoint? Okay, terrific. Thank you. So this year we've decided to make the announcements for the agendas for the Registrars meeting and the Law School Assembly one cycle earlier than last year. We've found that the more participation we get, the more valuable these meetings are. The Registrars meeting and the Law School Assembly are held each year. They are very unique meetings. They are the only meetings that we have that invite people from all of the California law schools. So the Law School Assembly is primarily an audience of deans, not only the dean of the law school, but deans of students, deans related to testing accommodation issues, et cetera. And we create this agenda with feedback from the law schools in mind. The more specific your questions, the more targeted we can make this. These law school assemblies in recent years have been an opportunity to have a two-way conversation and also to innovate as well. So for example, the Law School Assembly was the place where the idea for the Moral Character Working Group was hatched. And Dean Clancy was a part of that Moral Character Working Group. It created some terrific and helpful materials for both law schools and students when they are navigating the moral character determination process. That wasn't something that existed before. A need was identified and it happened. So thank you to Dean Clancy for your participation in that. It's a full day meeting. We plan to have it via Zoom as well. That was a really popular format the last two times we've done it that way. And this Law School Assembly portion is primarily related to state bar exams and strategic initiatives. The Registrars meeting, it's not open only to registrars. This past year, we had more interest in this meeting than ever, probably primarily due to Selena Flores joining us for the first ever public law school portal demonstration. So we had not only the registrars, but quite a few administrators from schools as well. So this is a more technical type of program, looking at state bar rules, state bar procedures, state bar systems like the applicant portal. It'll be taking place on September 20th. These meetings couldn't happen without you. You don't have to worry about whether you're submitting a topic as to whether it should be for the Law School Assembly or it should be for the Registrars meeting. We can figure that out. Sometimes a topic is even appropriate for both. We'll be reviewing the agenda at CSBARS next time, but prior to the meeting, in our next newsletter, we'll be discussing this and doing a call for topics. We would love to hear not only very general topics, but very specific topics. Selena will talk a little bit more about one where we've made some changes related to the certification process. When an applicant registers for the bar exam, they can do much of the material themselves, but they ultimately need certification from the law schools. We got a request to change that wording to make it a little bit more informative, clarify it a little bit for the students, reduce the number of questions to the law schools. And that's an example of a change we made. So it was very specific down to the level of the wording of a single line in the applicant portal. So questions at all levels, at all points in the funnel, from very broad to very narrow, are welcome at these meetings. We always will discuss the key initiatives or key changes that have been going on during the year at the State Bar, but we'd also love to know what else is on your mind and the priority of the different questions. So we don't have anything specifically agendized for discussion other than to name specific topics, but if there are any topics in mind, we could take them now, but otherwise I'll send a follow-up communication as to this. We just want to remind the schools in several different ways so that we can get the best feedback possible and make the most valuable meeting for you. Dean Leo.
Yeah, I've got one, and it's pretty timely. It would be to provide a little more transparency and guidance from the eligibility department in regard to the certification of our students for the first year exam. You know, one of the things that I see and have seen since I've been dean is, well, I'll tell you one thing I would like them to do is to change the wording of the email that our students, my students, get when they don't have, that is, eligibility doesn't have their transcripts. Because if you read that email fairly, it looks like the law schools dropped the ball, where, you know, we're dragging our feet and we're not sending transcripts on a timely basis to the very busy and probably overworked folks in the eligibility department. So I wake up some mornings, as other deans, I think registered deans do, and you get a lot of panicked and some blunt emails from students saying, why hasn't my transcripts been sent? And we have to go through the process that we've explained to them. We can't until we get the certification form. And when the forms are delayed being sent out, I think that's what triggers that email. And then, you know, it just ramps up the anxiety of the students who are in the middle of getting ready for the exam. So, you know, maybe a better description on the website, or a more specific timeline, and to hear it from the bar, that is something on the bar's website, to the students who are registering, to explain that process, so that they know that the law school has to follow this procedure. It has for years. We wait for the certification forms, we certify the transcripts, we send them back, and then there's a timing issue. And I you know, again, I'm not trying to be at all pejorative. It's just that I know it takes some time to get those out, particularly for the June administration. Again, eligibility is swamped with people getting ready, registering for the bar exam, and, you know, the folks getting ready for the June first year are somewhere in the mix. So when they're delayed, it just creates, again, anxiety that is unnecessary.
Okay, well, I'll make a note of that. And just a reminder, the current wording was actually made in collaboration with the law schools. So I'll touch base with you offline to try to get some specific suggestions that could be more helpful.
That the email that the students get, that must have been a collab. I mean, that's been used for years, to my knowledge.
No, it was recently updated, but we can talk about whether further updates are needed, and we can talk about it offline. Yeah, are there any other topics to suggest with discussion coming later when we've agendized them for discussion? And I see next Dean Park.
Thank you. So I just want to say, having attended both of the law school assembly meetings and registrars meetings last year, just to accompany my staff and to understand what they're saying, I found it very helpful. I think the addition of having dean of students there, or staff that are often in a position of wanting to counsel student with up-to-date information, it was very helpful. A suggestion I have, I think the State Bar has been doing a great job of looping in the deans, especially to those communications that students are getting before the CBX. I am wondering if there is something similar, maybe it's something deans can opt into or subscribe to when it comes to the first year law students examination. And I only raise that because it's relatively recent where really the modalities of those exams are distinctly different rather than kind of being more on the same boat with the first year law students examination remaining online and the CBX exams going in person. And I know for my staff, we just want to be sure to be addressing the concerns of the students about those modalities, make sure they're getting the information that they need and helping them through their stress and making sure they're being responsive. So that was a suggestion I had. And I see already on the next agenda topic a mention of testing accommodations, which is great. I think that what I'm suggesting here, maybe perhaps is going to be served by the next agenda topic. But that was one thing that came to mind when I checked with staff, is just again, being in the position of sort of hearing from them as they're going through processing. It seems like the ones that are seeking testing accommodations are exhibiting the most stress or feeling sort of the need to try to engage and ask a lot of questions to law school staff if they feel like they're not hearing enough, or they feel like their application is, they're not hearing a response back on it. So I'm sure there's ways to have a two-way dialogue about how to help those students through their anxiety and keep them focused on the step that they need to. And obviously, if anything's missing, to get that addressed and clear to the student side. But if there's nothing missing and it's more of a processing timeframe, that the school can be supportive and kind of make sure to guide the student to focus on the right information at that point. So those are my suggestions.
Thank you, Dean Park. Dean Friedberg.
Just another note on the context of Dean Leal's comment. I think everything can always be done better no matter what. I think that's why we're in education. On our side, for my school, we have a similar issue as it relates to the GBX certifications, especially for the spring graduates. They sit for their exams for our school in May, they get their grades in June. And it's always a question of timing for certification when the notices go out. On our side, what we found is as they do the graduation petition packet, that we give them a prophylactic warning that they may receive a notice from the bar that they have not been certified in time, but this is normal. This is part of our process. And I find that the students always have an emotional reaction to anything from the bar, I think, as most attorneys do. Even I, to this day, if I get something from the bar, I go, oh, what is this? So I think we have that reaction. But I think having those notices before they receive an email or notice from the bar has been very helpful, at least for our students. So just wanted to give that, that's one of our best practices we've developed over the years.
Thanks, Dean Friedberg. Okay, so this is a great start, and we're going to make an additional call and appreciate also the very specific questions. It's definitely going to help. And at this point, I believe we're ready to go on to our next topic with Audrey Ching related to the testing accommodation stakeholder input form.
Thank you. I just want to make you all aware, and I will be sending out an official Zoom invite to everyone on our distribution list, not just the CSBARS group here, but all the deans and administrators that we distribute all the communication to, inviting you to participate and to let all your students and alumni know as well in this testing accommodation stakeholder input forum. That's what we are calling it. It's a lot of words, but I think it's going to be really great. We're looking at reviewing and revising the process for petitioning for testing accommodations for our exams. So we're having basically an open forum from 10 a.m. to 4 p.m. on June 29th. That's a Wednesday, so 2 weeks from today. You can also, it'll be, over Zoom, but if you know anyone who would like to come in person, we also will have both offices open, the LA office and the San Francisco office. Because of the nature of the meeting, we've, in advance of even getting any requests for reasonable accommodations, we'll have ASL interpreters and third-party closed captioning at the meeting. I've also put out a call to all the past testing accommodation applicants, asking if they want to provide written comments in advance, and that'll be included in the official invite with a Zoom link too. So we're receiving some written comments. Welcome to written comments from you all as well, and any kind of comment you want to give at the stakeholder meeting. Again, it's going to be a lot of us there on the Zoom all day, just receiving the comments as they come and making sure we archive all of them. Because we'll have the third party closed captioning, we'll also get that full transcript. So we'll have all of the comments fully transcribed to put with the written comment we've received in advance. So just want to make you aware, I will be sending you out, again, an invitation with the Zoom link. It's on the public meeting calendar too. So if you do follow all our public meetings, it's on the calendar. We'll get the agenda posted by Friday. It's not going to be much of agenda really, but talking about this desire to get a lot of feedback from our stakeholders, which includes you, of course, in advance of kind of reviewing and revising this whole process. So we really hope you can at least drop in or send some comment along the way for the meeting. That's all I had. You're muted, but you're saying wonderful job, Audrey.
I am. So we're at the point where we'll be discussing recent developments just briefly. The first one is that several law schools have been following the paraprofessional proposal that's being discussed at the board level. So I want to direct your attention to the minutes from the May 19th and 20 board meeting where that discussion happened. Most recently, the proposal was modified. There also was an alternative proposal that was presented, and these options will be presented to the Supreme Court for their consideration. So feel free to take a look at those if your school has been following along. But in the meantime, back to eligibility, a topic that we already know is drawing a lot of interest. We've brought our program supervisor, Selena Flores from the eligibility department, to give some helpful reminders and updates from eligibility. So thank you for coming, Selena.
Thank you for having me. Good afternoon, everyone. So today I'll be discussing details relating to the two documents the law school will receive once a student applies for an examination. I will first discuss the certification process, and then the preliminary allocation process will follow. In my presentation, I'll be providing information detailing the process and the purpose for each. One point that I would like to make before getting started is just to remind all law schools that they should ensure that they have the most up-to-date contact information on record. I'd suggested that law schools create a general email account to ensure that all communication that we send is actually received. We often find that law school official emails are sometimes tied to a particular person, and it's a challenge when that person is no longer with the law school. Then we find that there are emails that are not received. Our system at this moment is only equipped to accommodate one official law school email at this time for eligibility purposes. So let me move on to certifications. So a certification is a document which is mailed to the official law school email address, and it's sent to them approximately 8 weeks prior to the first year law students examination and the general bar examination. The document contains names of students who have applied for the examination for the very first time. Once you receive the document, you will be asked to verify that the dates of attendance are correct and whether the applicant has satisfied the legal educational requirements to take the bar exam. The document must be received by the final eligibility deadline, which is 2 weeks prior to an examination. After a student is determined to be eligible, that student will no longer appear on any future certifications. It is preferred that the original certification be submitted along with the official sealed transcripts or official transcripts by U.S. postal mail. If it's not feasible to include the transcript by the final eligibility deadline, it's required that the transcript be received no later than 15 days following the examination. However, the signed certification will still be required in order for the determination to be made, and also to avoid abandonment of the applicant's application. The transcript must include the subject studied, grades, credit received, and the date the JD was awarded. If you're unable to certify a student, an official transcript must be received by the final eligibility deadline in order for the eligibility to be determined and for the applicant to receive an ineligible refund. Please keep in mind that students who are qualifying for the examination by completing an LLM will not be on the certification list. These applicants are responsible for requesting and submitting a transcript on their own. If the certification is not received within 2 weeks prior to the final eligibility deadline, the student will be sent an email informing them that the transcript is required in order for their eligibility to be determined. And George, this is what you were talking about. So our office has received feedback that the email generates calls and anxiousness amongst your students. And in response to that, with the upcoming July bar examination, a change was made to the language in that email in consultation with the California Law School stakeholders at a registrars meeting. This past registrars meeting that will hopefully reduce the calls and anxiety for your students. The eligibility staff works together with the deans and registrar to ensure that the students who have applied for an examination receive the eligibility determination no later than 2 days after the final eligibility deadline. The final eligibility deadline for the upcoming July exam is July 12th, 2022. And the final eligibility deadline for the June exam was yesterday, June 14th. Are there any questions with regards to the certification process? I'm sorry, you're on mute.
Maybe a suggestion not to add to your workload, but maybe a blast email to all the schools registered with regard to both the first year and the CBX and the CALs for the CBX, just saying, you know, as of you just said, Selena, that for instance, for the upcoming June exam, certification forms went out 8 weeks ahead of time. That's the end of April, May, I mean, May 1st.
It usually happens the first week of May, yes.
But do you send out a blast email to all the schools saying FYI certification forms have been sent out? Because I don't think I've never seen one like that. It would certainly let me and my registrar or assistant registrar know we should see them soon. And if we don't see them soon, and when we haven't, we've been remiss in waiting longer than reasonable to then contact Nathalie or Patty. So could you, I don't think that's done, but think about adding just for each of the exams, bar and first year, when those go out, just tell the schools they've been sent out. And that way we can let the students know they're on their way, and we'll follow up and get transcripts into eligibility as soon as possible.
Okay, I'll note that. Thank you.
It's the not knowing. I mean, we again just trying to be deferential to the work demands that eligibility has. You know, I've told my students, don't call. I mean, we will hear from the bar and sort of let us worry about it. And then we let too much time pass, and then they get the email, and then everybody starts running around and trying to solve the problem. So if we know they're on their way, we can let the students know. And if we don't see them, actually show up in our email box, then we know there's some issue either on our end or at your end, and we can then rectify it much sooner than we have very recently.
Thank you. All right. Are there any more questions? No. Okay, so up next, I will discuss the process for the preliminary allocation. So approximately 1 week prior to the first year law student exam and general bar examinations, the preliminary allocation list will be sent to the law school's official email address on file. This will include the list of applicants who have applied for the examination who are allocated to your school, excluding LLM students and or attorneys from other states who've gained admission prior to sitting for a bar examination here in California. The purpose of the preliminary allocation process is to allow an opportunity for the law school to make any corrections and or address any concerns prior to the final pass and fail list, or otherwise known as the final allocation. And making corrections to the preliminary allocation at the preliminary allocation stage will allow for the pass and fail list to be accurate, which will also allow for accurate statistics. The deadline for the review and response of the preliminary allocation is 1 month from the examination date. If your preliminary allocation list is correct, a simple email to the eligibility staff confirming so would be great. The response from law schools has increased within the last couple of administrations, which is greatly helpful and appreciated. Are there any questions with regards to the preliminary allocation list?
I just have a staff comment regarding the preliminary allocation list. After the preliminary, of course, comes the final allocation list, which is also the pass-fail list that comes out as your result list. And some schools will wait until that point for the pass-fail list, but we encourage you to look at the preliminary allocation list and respond as to that one. It helps to speed the production of the statistics and the posting of the statistics after the exam. So if you can focus your attention on the preliminary allocation list, we'd really appreciate it.
Okay, and we can't stress enough, it's very important for students to register. So we would like your help to encourage law students to register within the first 90 days of law study. And one of the ways to ensure that this happens is to request your students to provide a copy of the acknowledgement notice that they receive once they submit their application. Some law schools encourage it by offering discounts or then being entered into a raffle so long as they provide evidence that they've registered within the first 90 days. If you have a student who has registered but has forgotten their password and no longer has access to the email account that they initially created their account with, they will have to contact the admissions office so that they can have their account reset. We do not want them to create another account because that, of course, requires a merging of account and things of that sort. So if they forget their password and have no access to their old email address, we request that they contact the admissions office. Registering with the State Bar gives students practice complying with rules, allows them to be notified directly of opportunities like State Bar Day and other helpful information and it also helps prepare their record for the MPRE scores to be received. They should be sure that they are registered with the State Bar prior to taking the MPRE, or else they will not have any place to attach their results. If they forget to register, they will need to write the State Bar after registering to request that the scores be added to their record, even if they previously authorized the NCDE to submit their scores to California. And lastly, it would be helpful to us if you can periodically remind your students to update their information right away should they be a transfer student or have a name change or an address change. We require that they submit a general request and or change their address through their applicant portal, just so we have the most up-to-date information on file. Are there any questions about registration? Nicole Mills.
Nicole is a member of the public, and at this point, public comment is closed. So I sent an offline communication encouraging her to submit a public comment.
Okay,
Thanks, Alina.
thank you.
Dean Fickberg, I'll turn it back to you for the discussion portion of the meeting.
Thank you. I think we have Ms. Mills still with our group at this time. If she will return to our audience, please.
Yes.
And our next areas are call for participation in the planning for presentation to the Committee of Bar Examiners on non-JD law programs.
Yeah.
Is our next item.
Yes, and I'm going to share my screen just a moment to discuss that. Okay, can everyone see my presentation? Okay, terrific. So at a recent CBE meeting, there was a discussion as to not only the JD programs over which the State Bar has regulatory authority, but also what the current trends might be in professional law degrees that are not JD programs. So the State Bar will be preparing a presentation, staff will be preparing a presentation for the CBE in this area. As we get ready to do so, we wanted to invite California law schools to provide input about the trends that you see, or also the role that these programs play in your law school. It might be possible also to include summaries of some of the specific programs that our California law schools have been offering. And also how they may have changed, if they have changed during the pandemic or through the addition of online education. As part of this presentation, we envision that we will review the applicable State Bar rules, for example, the LLM programs that are used by those that earn a first foreign degree in law in order to earn eligibility to take the bar exam. We'll talk about the range of programs that are available. There seems to be a much wider range and many more specific programs that were available in the past. Other trends that we might see either stemming out of online or pandemic or other purposes. And I wonder if there are other areas of interest that you think might be helpful to the committee in understanding the role that non-JD programs can play in a law school. You need not share all of those now, though you're welcome to do so. This will also be part of a call that we'll be sharing more widely. And I know that several of our CSBARS member schools do have non-JD programs now at their law school. So if you have any other general topic areas to suggest, we would appreciate hearing them. Dean Fickberg?
Just a question. I know it said non-JD. Would the discussion also include the JD? I think some schools have called executive JD programs that do not qualify for the bar examination. Does it include that in the dialogue or just the non-JD program itself?
I think that's a great idea, yes. And I wonder, as you're making a comment, if it would also include some of the pre-programs that law schools have, such as the pre-program at your school, UWLA, where students who might be interested in undertaking a JD program can try something out. Do you think that that is a type of program that could be a helpful topic?
I think so. Ours is the performance program, and we use that in conjunction with the LSAT as a qualifier for admission into our school if the applicant has a lower LSAT score.
Thank you. And Dean Park?
Thank you. I was just curious about that last slide. I went quickly, but it said something about a newsletter survey.
Oh yeah, in the next newsletter, we'll be doing a call and we'll be asking the schools to report a little bit about their non-JD programs that they're offering right now.
Great. And I again, going off of non-JD, so everything offered at the law school, like LLMs, or so there can be some pathways that are bar eligible, and then I guess the pathways that are not bar eligible.
Right.
In that range. Thank you.
Mhm. Yeah, thank you. Okay, so you'll hear more about that. Just wanted to get it on everyone's radar to get maximum participation.
Thank you. So our next agenda item is our discussion and hopefully final drafting of our recommendation for guideline 1.11 for the registered unaccredited schools. I believe at this time we've already had our Word document version that shows all the submittals from our different teams, as well as the staff that definitely went above and beyond and helped to combine them in the form that I think it's easier for all of us to digest on a paragraph by paragraph basis. Ms. Leonard, is it possible to show that to our group?
Yes, I'm going to bring that up now. So this page is the full wording at this point, and then above I've got paragraph by paragraph, and you can just direct me where you'd like me to start.
Why don't we scroll to that first paragraph, and then we can see if there's any discussion within our group on each one of the paragraphs.
And for the benefit of the public, what I'm showing is the document that is attached to item F, that memorandum. It's just obviously in an editable format so that the committee can make changes if they so desire. Okay, here's our first paragraph.
So from our committee membership, and Dean Clancy, I see every hand up. Would you like to discuss some part of this currently?
Excuse me, I wanted to suggest possibly the addition of one word, and that's in the first line before the words bar examination, and the word would be California. Our schools are focused on getting people qualified for the California bar examination, and I wouldn't guess that we would wish to imply that we might be helping them qualify for the bar examination in any other state. For that reason, I think that the word California would be appropriate in that sentence. What do you think?
I'm supportive of that. We're just taking what is being inferred, making it express, and I think that is always better in a drafting document like this. I don't know if there's any other comments from our committee membership.
I would agree with Dean Clancy's point.
So with that addition, looking at our first paragraph, and again, we have our 3 submittals from the teams as well as staff's consolidated draft that's now highlighted. Dean Park, you have your hand up.
I just wanted to say, I did have a comment about the consolidated draft and the addition of which may be taught by law school, which I think is unique compared to what the subcommittees provided. And I don't want to get ahead of everyone, but just to make my point briefly, I remember that a concern that the subcommittees discussed before was just making sure that this definition wouldn't be of the type that could get, that would over broadly identify law school courses to be bar exam test prep courses when they're not. And while I'm sure everyone in good faith would interpret this in the way that's logical, I was worried about how that, because what's before there is standardized time closed book exams that focus on general principles of law, legal doctrine, and which may be taught by law school. And I just felt that which may be taught by law school perhaps overly broadened that scope of definition, because now I can see there's courses I have that are timed closed book examinations that focus on general principles of legal doctrine and which may be taught at law school that now fit in that part. This might be me being overly cautious because there's still that point number 1 review of materials previously covered in curriculum. But as people mentioned, a class like remedies that may review materials previously covered in curriculum and yet is not a bar exam test prep course can kind of fall in a gray area. So in terms of a simple way to think about how to adjust the language, maybe which may be taught by law school should be language that's reevaluated. I'm happy to answer any questions if there are any from me raising the point.
Well, on that point, Dean Park, is it so much that may be taught or are historically taught? Because we have our examples prior of standardized time closed book, which I think are the traditional domain of the California Bar, the first year law students exam as an example. Is there a different language that you might recommend?
I think in our subcommittee's proposal, we had a lot of specific language that defined the bar review course to be, primarily focused on reinforcing previous study substantive law for bar examination practice and guiding students to practice and take bar examinations. And I wouldn't say that we import all of that, but I just would want to point out that when we crafted that language, we were very much trying to avoid gray areas with it. And I think our subcommittee's write-up of that, it doesn't run into as much, remedies, as a class that will be misclassified. So hope that would help.
Oh, definitely. Dean Leal, I see your hand up.
Yes, thank you. Hopefully I'm not muted. Actually, I think there's a misplaced closed parentheses because the language starting with "and which may be taught by a law school" is still modifying the tests administered by or examination administered by the bar exam, i.e. standardized time closed book. So I think the parentheses should be placed after legal doctrine, and then at the end is superfluous, which may be taught by a law school. I'd include faculty or a commercial preparation company, and take out the other, delete the, because I think it just is confusing the way that the parentheses were in the draft.
No, I definitely see that. I think that is a good, and I think that actually goes in part to what Dean Park was just saying, because then we're truncating that area of which portions are more bar domain versus law school domain.
And thank you for that email. I think the original draft, that was one thing I commented on. I wasn't sure where the ending parentheses would go, and I actually suggested at the end because I assumed it was at the end. So thanks for taking a critical look at that.
And again, and I think it's superfluous. Just say which may be taught by a law school or commercial. You could take preparation too, just a commercial company. I would think, just for brevity's sake.
And were there any other potential conversations, Dean Leal, for that first paragraph? Hearing none, Dean Keller, you have your hand up.
Yes, thanks. So 2 points, one following on the one we were just talking about. I agree with where the parentheses are now. I think that makes sense and is helpful. I think the language about which may be taught, who's teaching these courses, should not be in this part. It's addressed, if you look at the full consolidation, it's addressed later who can teach these courses and whether they can be required and all of that. So I don't think it even needs to be here, and that could eliminate the potential confusion.
I second that edit. I think I agree. The entire phrase is superfluous.
And second, I think that this is still a little bit overbroad in that we're saying a course contains review of materials and contains, I'm not sure what contains means here, but contains the unique particularity of examinations administered by the state bar, meaning standardized time, closed book, as was, I think, just mentioned. That's remedies, and in large part, but that I don't think we were thinking that remedies, which is going to review torts, contracts, property principles, and which, if it is taught in a way that has a time closed book examination with multiple choice and bar-like essays, now that's suddenly a bar prep course. But I don't think that's what was intended based on our prior discussions. So my suggestions there would be to include some language as previously was included with regard to the primary focus. If it's defined as containing both of the following, one, the review of materials, and two, with a primary focus on the unique particularity or something like that. I'm doing this on the fly because I didn't really catch this earlier. But I would hopefully somebody has a more elegant drafting suggestion there. But I do think something like that is necessary so that this isn't overbroad.
No, I think that's well said. And I think if we just insert that language right after Arabic numeral 2, where it says the unique particularity, so we just have there with a primary focus on the unique particularity, and then take over from that point again after number 2.
Does
Does
that
that-
capture it correctly?
Yes, at least capture what I was saying. I don't know if we captured what Dean Keller was telling us.
Yes, I think that's what I said. And if it's not, this is good. So I like it.
Okay, thank you.
So I think that definitely addresses at least the concerns I remember us having as a group. Again, how do we distinguish remedies, or how do we distinguish later upper division courses that would build on prior ones? Well, the primary focus is on ABC, the unique particularity of the bar. Dean Keller?
Yeah, just wanted to add, as you were just saying that, my preference, and I don't want to speak for my teammates since he's not here, but our prior position, at least that we put forward, was we should not have a definition and we should not have a units limit at all. Even with this change, I'm still concerned about who's interpreting this language, whether it's done fairly and consistently across time, across schools. So if I were drafting it, I would not have this piece at all. So I did want to just register that for the record.
And definitely well received. I think that from our beginning, this was the most nebulous area. How do we define what a bar review is, especially in comparison to a legal writing class or advanced legal writing class, or more practicum focused? So this is a difficult one in drafting. Is there any other additional comments on the first paragraph of our consensus build here? Dean Park?
I just want to echo what Dean Keller said. I think this is an improved definition that's getting at reducing gray areas, but I have the same concern about establishing a max limit in combination with this language that she does. And when we reach that paragraph, I will speak again on that. Thank you.
So I think at least for our drafting purposes right now, we have a consensus version of our first paragraph. Maybe we should move on to our second paragraph now of the consensus build.
And it should be clear that consistent with the discussion that has already started, I got the sense that the CSBARS recommendation was not to have a limit, but if the committee wanted a point of view on a limit, then the double bracketed language is what I gleaned from the discussion.
Well, I think that's a good catch. Why don't we jump to that third paragraph, just that portion, because I think that tied in well to what Dean Park was just referencing and Dean Keller was referencing. So maybe this portion can help us better understand and accept potentially the definition we're talking about. So looking at our third paragraph consolidated just within that bracketed yellow highlighted portion. Again, this is the conversation of the limit to that definition of how many units. Is there any dialogue from our group on drafting, redrafting that portion in yellow on the screen currently? And Dean Park, I believe your hand is up.
Yes, actually, yes. What I wanted to speak on this paragraph is in our subcommittee's draft, we actually kept this to a separate note to say, if there's a reason that a maximum must be imposed, this would capture the numerical limit that we would be most comfortable with, which Natalie just shared as well. So I just want to make sure that context was conveyed into this document. I knew I could do so orally. It is really, and I don't mean to speak beyond what we submitted for Dean Clancy and me, but while we did provide this, and it comes from, again, kind of a abbreviated look that we did for the time that we spent on it, it wouldn't be in our position to put this language in. If it's possible to not establish a maximum limit, that would be our first stance. And then this is only to provide language if there must be some sort of maximum imposed. But in terms of input into that, I think it's still unclear why we would do that. I think in light of what we can see with law schools, how they're trying to offer things for their students, their diverse range of students. And if that restriction is just not existing elsewhere, I think it's still a very open question why we would assume it needs to be done here, or at least at this time here and not later on.
So Ms. Leonard, would it be appropriate for our committee that if we have a consensus draft to give to the Committee of Bar Examiners, could we put a notation that the recommendation is not to have a limit, but if there is to be a limit imposed, this is the limit that the CSBARS has found acceptable?
That sounds like the clear consensus of the committee, certainly.
Mm-hmm. And Dean Leal, you have your hand up.
Yes, in the highlighted language, it's all about requiring a maximum, but if as in our case, it's a voluntary, they're elected, it's both the first year and bar. So should we add in law school may offer or require a maximum of 12 semester units or equivalent?
Doesn't that change, just limit it more?
I'm
Now
sorry.
you're limiting how much you can offer as opposed to how much you can require. If there's going to be a limit, I would think that schools would rather it be, okay, I can only require 12, but I can offer and strongly suggest however many more I think is appropriate.
Well, no, that's an excellent point, and I guess that's a way around it. If we were, I mean, if we wanted to avoid that limitation, we would just have additional units beyond 12. I'd be concerned about that because given what Mr. Kramer's comments, I mean, I don't know what other schools would offer. We would, I mean, my plan right now is to offer, 6 units, 4 for bar and 2 for the first year. So I'm not too worried about 12, but I would be concerned with the committee's idea that this is some way around or giving schools the potential freedom to offer more than 12.
Well, as a friendly amendment, potentially, instead of offer, maybe we could change the language to a law school may, as we have already, a law school may grant rather than offer or require, grant a maximum of 12 units. Because as an example, just within my institution, we have our academic support classes. They can only take once for credit, but they can take those classes again for no credit at no cost.
So that's a good idea. I mean, so they grant a maximum of 12 academic units of credit, it would be the appropriate limiting factor.
Exactly. But do you think that would resolve that potential issue?
Yeah, I mean, again, I'm just trying to be, for a moment, an honest broker here, to address what might be the committee's concerns that schools would somehow do an end run around this limitation and allow, or, to give students upwards of how many more than 12, 15, 18, 20, whatever it might be. It might get into a definitional kind of, but I think the way we've modified it might achieve both goals, giving schools maximum freedom to do what they want for purposes of credit up to 12, and then making it clear that there is a limit on the credit that students would be permitted to earn.
And Dean Park, I don't know if your hand is still up or.
Oh, I did leave it up, but I do want to just say that reminder. Everything we said about paragraph 1, I think is still relevant here, where whatever the number is, there is that desire that we would understand how paragraph 1 would be applied consistently, especially in the context of a compliance or non-compliance determination.
Okay, definitely. So looking at our yellow highlighted portion now with our edit of the law school may grant a maximum of 12 semester units or equivalent. Do we have any further discussion on that? Again, with the notation that Ms. Leonard will make sure that is communicated to the committee bar examiners that our preference would be to have no limit, but if there is a limit, this is the language of the limitation that we would support. So I think we have consensus on the yellow portion. Maybe we can go back to that first paragraph again from Dean Park's last comment.
Might I make a comment or a question for the group regarding the number? The committee might also look at this as a percentage, and I think that this 12 was hewing back to something like the limit for the internships that you see in the accredited law section. In the registered area, there is some more latitude as to the total number of credits required for a degree. So for example, Dean Leal mentioned a lower number at his school, but at the same time, his JD program has a 64 credit program, and they're very rich credits. Other programs may have over 90. So potentially, but similar content. So potentially the committee might look at a percentage. And I wanted to just get a sense from the group. Are you looking at something like a 10 to 12% of credits range with that 12 semester number, emphasizing that the preference of CSBARS would be no limit?
And I don't think our program, actually, that was an earlier draft. We're at 80 units for the finalized approved program. And that's why I'm working with 8, because that's 10%, looking at it, a percentage, which I don't think anybody would object to, but that's just specific to my program.
Okay.
I just want to mention I have a 140 quarter unit program, so as a registered law school, so the percentage definitely can vary, especially if it's carrying more than the minimum. But I do think possibly the 12 semester units of their equivalent might have been thinking about there's a context that there is a minimum of 80 semester units in a JD program, at least at the accredited level. So 12 divided by 80 might be a good point. And I think that might be 15, if I'm not wrong. Never should do math.
That's what I got as well, and I think
okay,
that
great. Thank you.
That is what consistent with what we had said earlier.
Thank you.
Okay, so I'm hearing it as a consensus percentage. If there is to be a max percentage, might be about 15%.
I think we have consensus from our group on that, unless I'm misinterpreting it. I see everyone nodding.
I agree to that.
Okay, I'm not sure if that will be the committee's preference, but it's something that I've heard in the past, so I just raised it as a possibility. Thank you for that.
No, thank you. I think it's the same way of looking, but if they interpret percentage as a better, then at least know what our standard would be if they would like to have that limitation. So I think that's a very good catch. So at this stage, I believe we have a consensus now with a much improved version of our yellow highlighted area. If we could scroll back to our first paragraph, because I think Dean Park wanted to address further the first paragraph in light of what we just said with the yellow highlighted section. Dean Park, any recommendations on redrafting or making changes to this one?
I think what was said just basically, because this is new language being drafted, because there's not a lot to benchmark this to, there's just that concern of how it would be applied or interpreted, especially for something as critical as a non-compliance determination, which I'm sure that every law school would absolutely want to avoid as long as there's clarity up front. And I think this language that we have goes a long way to be an improvement. I think the primary focus definitely helps it here. And yeah, my concern of which may be taught by law school, that piece, I think if that is deleted, it's not going to be as concerning as it was to me in the original draft. So I think we're going a long way to that improved definition. There may be more room to try to avoid gray area, but I can't think of that now beyond what we've done in this session. But I hope when the draft does get submitted to the Committee of Bar Examiners, especially since CSBARS is talked about as being the expert input into this, I hope we can still clarify that point, that there's not a lot of benchmarks to define this area related to compliance or non-compliance determinations. And so if that max credit limit is going to have to be imposed, that is a part of that discussion, that registers, that's part of our input from CSBARS.
No, definitely. And again, our goal is to have our draft proposal completed today, so that way it could be heard at the next Committee Bar Examiners meeting when they have this itemized. So I think that yellow highlighted section within the first paragraph we're looking at potentially might be deleted based on our later conversation. Dean Keller, you have your hand up?
That's exactly what I was going to say. I think we have a consensus to delete that. So I think we can just delete it rather than flagging it as a consideration of deleting.
Dean Clancy?
I think it was mentioned that wording is picked up in the last paragraph.
Mhm.
So leaving it in the first would merely be a redundancy. So to prevent the redundancy, just take it out in the first paragraph, but it certainly is in the last paragraph. So we've not lost anything.
So yeah, so I would suggest not only just deleting the consider deleting, so that it's clear that that is the group's consensus. Thanks.
So now looking at our first paragraph as edited, do we have any further discussion on that first paragraph? If you're not hearing anything, why don't we go to our second paragraph of the consolidated draft?
Oops. Sorry, that's 3.
So looking at our second consolidated draft recommendation, do we have any discussion from our committee for editing, deletions, or changes? Okay, hearing none. I think we have good drafting there done. Excellent. Now going to our third paragraph. So again, the yellow highlighted portion we've already resolved. Is there any further discussion in our consolidated draft that is not highlighted in yellow? Dean Keller?
Yes, so I I'm fine with the first clause. I'm a little confused by the second clause, must disclose to students any ownership interests, etc. And I guess where I get confused here is we're saying, let's assume we have a scenario where bar prep class, 3 units your last semester is required for graduation. And it is taught by people from a commercial review course, but students are charged tuition just like they are any other course. This rule or guideline would then require the law school to somehow disclose financial interest in that class, but not all of the other classes for which they're charging the same tuition. And so to me, that seems very confusing to students. And so maybe maybe others had something very different in mind, that this was a scenario where there would be some sort of outside review course that they were getting credits for, and that's why you need this disclosure. But to my mind, I would delete this part of the disclosure here and just leave it in the consolidated paragraph 4, where it refers to all of the guidelines about honesty, fairness, etc. With regard to schools.
Dean Keller, I think I can provide some insight here. This was the scenario in which a law school would contract with a commercial provider, but the law school or members of the law school would have a commercial interest in that provider. So for example, if the dean was also an owner of the bar exam prep class or something like that. I think it is certainly contemplated that the law school has commercial interest, or at least a nonprofit interest in its own law school. But this is when choosing an outside provider, if the law school or any members have an interest, that the students can know.
And and maybe if we rewrote it so that it said, like, if we are going, if the class is taught by an outside provider, then and an owner of the outside provider is also an owner, administrator, instructor, or staff, or something along the lines that you just explained, that narrows it a lot more, and it's more it makes more sense to me, I guess I would say. Especially when you start talking about instructors and staffs, I can imagine scenarios where someone might well be an adjunct who teaches a course for the law school and also teaches in a commercial course, but they wouldn't necessarily need to disclose an ownership interest unless they actually have some role in deciding that commercial review course is going to be used.
Okay, I'm sorry, can I confirm the edit that we would do here?
As an example, as a friendly amendment to the edit, potentially maybe we can convert that semicolon after program into a period and just separate these two areas out completely. So I don't believe we have any discussion on requiring a course as required as part of the JD program itself. So I think that part, unless I hear anything from our committee members, I think that part is safe, at least for my editing feature right now. The second part is more of the discussion that we've had of potential self-dealing. What is the disclosure requirement? And I think Dean Park, you have your hand up.
Yes, I think a struggle with writing this section was, it really came around or other financial interest, like I think that language. And the thought was, especially for the concerns for consumer protection and everything, obviously we want the law schools to be forthright with its students about how it's benefiting, from a course. But it's true, and going to Dean Keller's point, it's kind of inconsistent standard perhaps with the rest of curriculum. For example, if we include other financial interests to be, oh, the teacher has a licensing agreement over the text or the content being used. Well, that's something that can occur in other law school courses and yet won't be scrutinized nearly as hard or be seen as a compliance issue. Even the hiring of certain faculty to be in a course is not scrutinized as hard. So I do think there would be a benefit to clarifying, you know, in the other financial interest language, what is it really that we are worried about? I get it with ownership interest because, you know, an owner is getting the profits and we worry more about that self-dealing. But when, let's say, there's a teacher that has licensing agreement over content, you know, the fact that they offer them the course, it doesn't compute normally as ultimately self-dealing to them or to that administration. So perhaps other financial interests can be more fine-tuned. I wouldn't suggest striking it out and leaving it just to ownership interests, because maybe that goes too far. But if we keep or other financial interest, maybe we could discuss what is it that we're really worried about? What types of financial interests? And I hope I covered, I'm not arguing one way or another about it, but I hope I covered some types of financial interests that could be there, but it's not as if that's normally seen as self-dealing at a law school.
Understood. Just as a potential edit for discussion, I was wondering if we could add right where your cursor is, in the interest of transparency. A law school. And we can leave the rest just for our discussion purposes. Dean Clancy, you have your hand up.
Yes, I wanted to suggest some wording at the end of that long sentence, wording that would make it longer, but I think would clarify things just a bit more. And what I have in mind for the end of the sentence after the word course is the words for which credit can be granted by the school. Because otherwise, the wording prior to that addition makes it seem as though there's got to be a disclosure regarding ownership interest regarding any review course, not just the ones that the school's requiring students to attend. So I think it's clearer this way.
Understood. Dean Keller?
Yeah, so I was trying to jot down some language, which may be moot at this point, but you know, Natalie was asking for some suggested language. I didn't have any, but so this is what I came up with. People think it's worth exploring, great. If not, that's fine. But instead of, I was thinking of in replacing the interest of transparency sentence that we have now with something like, if a school contracts with an outside commercial entity to offer the required test preparation course, it must disclose, and this is where I'm not quite sure where to go, it must disclose, you know, whether the decision makers or administration or whatever limit we want to have it, you know, has any ownership interest, you know, in that commercial entity. I guess I'm trying to cabin it to the specific situation that Natalie was talking about, so there's not a potential confusion down the line. Like let's say a school partners with Themis to offer a course, then it could potentially fall under this disclosure, because it would be a commercial review course if Themis is partly providing materials or teaching, but it might also be wholly integrated into the tuition structure and everything else, which goes back to my original concern. So that's where I was coming from with the, if a school is contracting with an outside entity to do this particular course, then that triggers these disclosures. What do you think?
Well, rather than transparency, maybe we should, from what I'm hearing from everyone, we should change language instead of transparency to consumer protection. That's the real interest that I'm hearing from Ms. Leonard, and I think we've heard from the committee discussion, not so much transparency is part of it, but it's really consumer protection. Dean Clancy?
I meant to take the hand down, sorry.
Not a problem.
And
So Mr.
Dean Fickberg, at this point, I want to just do a time check. We will have our guests ready to present at 2:40. And we can, if you prefer, delay the records discussion to the August agenda.
I think so, because this was the higher priority, and I think if we can have a public discussion on the first year law students exam multiple choice project, I think that'd be very beneficial for everyone. So I would support that.
Okay.
Thank you. Is it possible to change where it says transparency in our edit to consumer protection? Again, that way the committee will have a better understanding that we're trying to take to heart their concerns. And Dean Keller?
I'm totally fine with that. I think that makes sense to specify that's what we're talking about. I'm not sure if it still addresses the concern that this could potentially be applied to anything that might be labeled a commercial review course, and that could include classes that are either taught by or in tandem with, but are charged, tuition just in line with everything else. So in the interest of community protection, a law school must disclose to students any ownership interest or financial interest in any outside commercial entity that is being contracted with to provide the course for which credit can be granted. I'm not sure if even that really solves the issue, unless I'm overthinking it. But I suppose if this could apply to either, not just the bar exam, but the first year law students. So could be called a test preparation course.
I think that does capture well. Would it be possible to use external versus outside? External.
Yeah, that's better.
Language I've read elsewhere, but this is the exact same synonym. Dean Park.
This is just a suggestion, and I think I just usually try to draft the language so that there's less of a need for introduction of a new term. So what I was thinking could be, and I'll just suggest it from after the in the interest of consumer protection clause, is to put after that, if a law school grants credit for any, let me look at this, any particular commercial review course, I feel like having that as part of the language will help make the rest of this simpler, hopefully, because it seems like we're narrowing down the kind of triggering situation that these disclosures would need to take place. So I think if it's in the interest of consumer protection, if a law school grants credit for any particular commercial review course, then maybe the rest of the sentence can be narrowed down to just the obligations that get triggered from that point. And I put commercial review course because that's a term that's been used in our drafting so far. And I just feel it reduces the questions for someone to think, is one particular phrasing really implying something different from the other? I think commercial review course is what we mean. So in the interest of consumer, if a law school grants credit for any particular review course, I think that's a situation where we think disclosure should be triggered. So a law school must disclose to students any ownership interest or other financial interest of the law school, its owners, administration, and staff, and any external commercial entity being contracted with to provide a test preparation review course. So we could reduce some of the language in the rest of that sentence, for which credit can be granted by a law school. I think that could be deleted because that's duplicative with if a law school grants credit for any particular commercial review course, that concern's addressed there. And my only thought on sort of what remains here is that, you know, external commercial entity is now a new term being introduced. And test preparation review course is kind of a new variation of a term being introduced. So yeah, if we could maybe just have it be test preparation course, because that's what we have from our first paragraph, and strike out review, at least terms are being used consistently through our drafting. And
because we have our guests here at this time, might I suggest we turn to our guests and then extend the meeting a bit beyond 3 p.m. if everyone is amenable?
Any objection from our committee members to a potential extension of our time beyond 3, so we can finish the drafting after our special set is heard on the first year law students exam? Hearing none, then why don't we transition then to our special set for the presentation from the first year law students exam multiple choice project.
Appreciate your flexibility. Thank you.
Good afternoon, everyone. For those of you who don't know me, I haven't met before. My name's Lisa Cummins. I'm a principal program analyst here at State Bar overseeing exam development. And I'm just here to provide you with a short report on the first year law students exam multiple choice exam content review project. So the State Bar announced this project to review the content of the first year law students exam multiple choice exam via an email blast to all law schools in mid-April of 2022. There were several follow-up reminders were also sent. There are 2 phases to this project. The first being the content map review, and the second being the actual item review. Volunteers were solicited. Applications were accepted until May 2nd. We did receive 15 applications from all law school types. We ended up with 13 reviewers. We started with the content map review. We held 2 orientation sessions with 2 separate groups in May of 2022, well, just last month. And then reviewers were given homework to go through the 3 content maps, and that would be for contracts, criminal law, and torts. And each content map had a list of domains and subdomains listed. And they were asked to provide their evaluations, including whether the domain or subdomain is an important indicator of first year law school performance, and then the relative weights. And all reviewers have returned their worksheets, and our psychometricians are currently analyzing those results. So the next step is the item review phase. Staff is still working out the logistics for this review, which must take into consideration exam security concerns, of course, since we're actually reviewing actual items. And then I do also want to announce that for the October 2022 first year law students exam that we will be pilot testing 25 new multiple choice items. They will not be scored. And With 25 new items and in the total 100 item test, we will still be, the goal is still to maintain the validity and the reliability of the overall exam overall. So I can take any questions, and then also want to say that anyone who would like to comment on this topic, in the audience or in the public, is welcome to submit public comment. And I also want to mention that our State Bar psychometrician, Dr. Roger Bolus, is in the audience. And so if there are any questions that he needs to address, then he can be promoted to panelist.
Hi, Lisa. Can I ask a quick question?
Sure, George, how are you?
I'm good. It's great to see you.
Good, you too.
Just for context purposes, because I think there's a lot of urban myths that have permeated the ether for years with regard to how old the questions are, or the last time they were, edited or revised. Could you provide me and the other deans some idea of last time? And this may go back to your predecessor or his, when the staff spent time working with the multiple choice questions.
Well, when you say working with,
well, I guess a review, and I guess it begs the question is whether or not over, say, the last 8, 10, 20 years, there has been any effort to review, revise, and I don't know. I don't think any new ones have been added, right? So there's an issue of recycling. When students take the exam, and I hate to say this, but multiple times, there's a good chance that they're still not getting the right answer to a question they've already seen once, maybe even twice before. So that's as a dean and a professor, that's very troubling.
Well, as you know, George, you probably we do have 5 separate forms that we do rotate throughout. We rotate through administrations. We have not had a comprehensive review of the first year law students' multiple choice questions, not since I've been with the State Bar. But you also know that after every administration of the first year exam, our psychometrician does do an item analysis on how the items are performing, as well as an overall analysis of the reliability and validity of the exam. And that number has always been, has never been a concern in terms of the validity and reliability of the exam, even with its age. So that is not something that has been, something that has come up, because the exam has always been performing reliably and validly as it should.
Well, thank you for that.
And I don't know if Roger has anything to add, if he'd like to. Natalie, do you want to just promote Roger to?
Oh, I'm already promoted, Lisa.
Oh, you're already, okay, thanks.
I've been promoted. No, I don't think so. It is time that the examination has, this more thorough review, but we have, after every administration, as Lisa alluded to, we go through a statistical assessment of the how the items are performing. We haven't found any information or any evidence that suggests that because there are repeaters in the examination that they are doing any better or worse because they have been re-administered the exam. We've also indicated that there are 5 forms. While there are some applicants who've received sat for the exam multiple times, there's no evidence to suggest that they have memorized the actual questions and have performed any better or worse than the rest of the population. We did finish a statistical summary of the report of the data, and provided Amy that report, which actually did a kind of a 20-year review of the test performance. So that was actually part of this study that we're undertaking.
And George, just for your edification, for example, for the technical report, so and for the committee of bar examiners, Roger's technical report is always presented after the results have been released for the first year exam. And for the item for the June 2021 exam shows that the multiple choice exam had a 92%. 0.92 reliability score, and the overall total of the exam with the multiple choice and the essay portion was a 0.9 reliability. And then for the October 2021 exam, it was a 0.9 reliability on the multiple choice and a 0.91 reliability on the overall exam. So maybe Roger, you can give a sense of what 0.9 means in terms of reliability and what is like sort of the minimum reliability score you would want to see on an exam to ensure it's performing as it should.
Well, on a high stakes licensing examination such as the general bar, the minimum criteria is a 0.85. The reliability indicator is basically an index of sorts. The objective is to get as close to 1 as possible, which is pretty much impossible with most tests. And so the standards for education and psychological testing, which kind of is the primary guidance, there suggests 0.85 being the minimum, and anything preferably the results in the 90s are what we're looking for. That index is pretty much a indicator of how much measurement error resides in the examination. And so that's kind of why the levels of 0.85 or above are considered the operation standards. Now, this is not a licensing test, but it is a test in which there are significant decisions made on it. So we operate around that. We still maintain that standard of 0.85 or above. My historical analysis of that and report that I provided to Amy suggests that over the 20 years since the current version of test has been in operation, the indices haven't never fallen below 0.85.
Hello. I had my hand up, so I was gonna speak. So I just want to thank Lisa and Roger for the orientation. I think that's fine to say that I was a participant in the orientation for content map review, and I think it's a really exciting and refreshing opportunity for those who are stakeholders in the process to be able to comment on the structure and see how the exam is checked and developed. I just had 2 questions. So the first one was just, I know that there were 13 people selected, and I was among them, part of the 2 groups. So thank you for that very much, for that opportunity, and also to other school staff for that. I know for the item review, it might need to be a more fine-tuned group. So I was wondering if you had an idea the number of people will be participating in that round of things.
Yeah, so good question. What we have landed on, originally we were thinking that we were going to probably exclude faculty or law school representatives from law schools that had students that would take the exam, but we have the psychometricians have satisfied themselves that that is not. I mean, the intent is not that any one or two or group of reviewers is going to be exposed to all of the questions. It will be segmented, and it will be teams reviewing parts of the questions. So not everyone is going to be having all questions. And so we do intend at this point to engage all of the reviewers that we have agreed to participate in the project.
Great, so the 13. So,
Correct.
okay,
And
thank you.
Lisa, may I offer a clarification too? You mentioned that 15 applied and 13 are participating, but everyone was in fact accepted and 2 voluntarily withdrew based on schedule conflict. Is that correct?
Okay,
Correct.
great. No, thank you for that. My other question was just about how there will be 25 questions in, the next administration that will be of that unscored type. And I gather from the context of this, it's been a long time possibly that new questions have been introduced in that way. I just wanted to check, what would be disclosed to to those taking that exam about that situation, especially if it's a new one for the multiple choice bank. Just
Yeah.
hear that.
So what I anticipate is there will be a lot of advance, well, this being the first advance notice to law schools as well as applicants and the general public, that there will be 25 pilot questions, new questions introduced into the October first year law students exam administration, October 22, and that those will be unscored. So, we will maintain the 100 item test, which is what the standard of the test is currently, but we will be substituting 25 new questions, and they'll be randomly situated, and obviously the applicants won't know which ones are which.
Okay, thank you.
Yeah, I might add that a couple things with the items. There's several ways to test new items in a live testing situation, and we discussed a few options. One of which was to potentially have an additional period of testing that would go above and beyond the normal testing period. And I think we all came to the conclusion that that would be extremely difficult, and stepped away from that. Modern testing programs will, such as the National Conferences, MBE, routinely include test pilot items in their examination. So in a sense, what we're doing is kind of replicating that process. The idea being, if this process works going forward, rather than waiting as long as we have to implement new items into this test, we would probably have fewer items that would be tested each period, and be prepared to kind of refresh the item bank on a more periodic basis. The other thing that we will be doing is to evaluate how these items are performing. The items that were drafted, I guess, some time ago, were drafted from the existing domain map or the specification. So it's not as though there will be new areas tested, it's just new items. And we will be evaluating how those items perform. And I think if we deem that the items are performing at levels, they may be included to add some reliability to the test, but clearly there'll be an assessment of their performance before they're included in a final score.
Thanks. Danielle, you had your hand up.
Yes. This way, we don't have time today, but just for purposes of maybe a later discussion, a meeting, and certainly at the committee level, the question that comes to my mind, and it's anecdotal. So we use Adaptabar, very rigorously in our boot camp. My students are on it right now, I hope. And those questions are all, of course, done by the NCBE, geared for a licensing exam. And I've asked many of my students, how do those questions that you spend hours answering, often wrongly, compared to what you see on the actual exam? And it just, so the philosophical policy question is should the 100 questions that my students after 1 year of law school see on the first year exam be, in essence, equivalent from a testing perspective, a reliability perspective, frankly, from a difficulty perspective, as questions designed for licensure for people taking an exam after 3 or 4 years of law school. So, this is the black box that deans are looking at. We have no idea how these questions were drafted 20, 30, 40 years ago, how they're, and the answers were then, drafted along with the fact pattern. So my question is this, and for the issue to discuss, is it appropriate for the multiple choice questions of the first year exam, which is half the exam? If the standard being applied is what the NCBE has done forever on a bar exam, is that the standard that ought to be the policy of the committee for purposes of finding out whether a law student is sufficiently educated and has the skills and capability to move on and complete 3 more years of law school? And I bet you don't. If you have an answer to that question, I'm more than impressed. Or my question really is that part of this discussion that this group is going to get into to modify the exam in the long term, to perhaps change either the formatting, the content, or maybe not the content, but the difficulty of the questions compared to what you would see from an NCBE multiple choice question.
And Dean Frickberg, this may be an appropriate time to take that back as feedback and turn to our conclusion of our discussion of 1.11, as we are already at 3 o'clock and we have just a few minutes.
Definitely. Dr. Wallace, I don't know if you have a short answer to that. Probably not, but I definitely don't want to cut you off, but I will give you the option to say no if you want.
There is no necessarily a short answer to that question. Clearly, the items are different. They're targeted to a different subpopulation. They're not targeted. The idea behind these questions is, are people who perform well on these tasks eligible to move on? The purpose of the NCBE's MBE are for a different purpose. So they are essentially serving a different purpose, which is kind of at the heart of it in terms of the difficulty level. If you were to give these questions in theory to a population of seniors graduating and sitting for the bar, my guess is that they would perform much better. Now, part of the report that we did for Amy in State Bar, and the other one was to evaluate the relationship between the performance on the first year exam and the NCBE. Without going into another longer discussion, I could say the findings are remarkable in terms of their, given that all of the water that flows under the bridge from your 1L experience to time you take the State Bar, they're remarkably predictive. So,
I think that'd be our expectation as well. Just to be mindful of our time for everyone. Dr. Bolas, Ms. Cummins, thank you for your presentation, and definitely thank you for the effort to make a better instrument for the first year law students exam. I know that we all appreciate that on our end, so thank you.
You're welcome.
Ms. Leonard, could you pull up that 1.11? I think we left off in paragraph 3, just to be mindful of everyone's time here. I know they're donating their time to begin with. Now they're donating beyond their original anticipated donation of time. So we were on that paragraph 3, we're just redrafting. I think we got a little repetitive within that one as we're going through. Dean Keller, go ahead, please.
Sure. Yeah, actually, I was just going to pick up right with that point, Dean Frickberg. I think if I understood what Dean Park was saying, I think the language could be, oh, sorry, Natalie moved it. Now I got it. In the interest of consumer protection, if a law school grants credit for any particular commercial review course, a law school must disclose blah, 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 administrators, instructors, and staff, period. I think that would cover the points. I think the remaining point that I'm still have some concerns about, and I think Dean Park said as well, is the broadening it from ownership interests to other financial interests in parks. I'm not sure what that means. And then I'm also concerned about, particularly in connection with the financial interest, having an instructor or staff member with some sort of interest that must be disclosed. So I'm imagining someone, whether they're classified as an instructor or staff, they work, teach legal writing or some other class at the school, part-time. And then part-time, they work at one of the big commercial bar prep companies. So then when the school goes to that big company and says, oh yeah, we want you to teach our final semester class, now the school has to disclose and say, oh, hey, Professor so-and-so has a financial interest in that company because they work for them sometimes. Like, I suppose it's a financial interest because if the company's doing well, maybe they will keep working, get more hours, get more salary. I don't know, but that broader language seems potentially problematic to me there.
No, definitely. And I think right before it says we left one word out, school grants credit for any particular. I think if we could put back external commercial review, I think that was an important distinction that we had in the later version, that external commercial review course. And I'm not sure if there's a way that I can think of resolving the potential issue we have with owner, administrator, instructor, staff. I don't know if anyone has any context of the potential language that they would recommend to change that. As I think as Dean Keller said, the distinction, if we have a full-time faculty member within the university, but they also contract separately for an external commercial bar review, would they have to disclose that, and to what degree?
Yeah, I suppose one way to deal with that is if it were simply limited to an ownership interest in the commercial review company. That I think would definitely limit the likelihood of the part-time adjunct who is doing two different gigs, one at the school, one with a commercial bar review company, having to disclose things via the school to the student population. And to be clear, I don't think that students would care about that. In other words, I don't think that would be a consumer protection issue the way it would be if there was a significant ownership interest in any of these actors.
So with the deletion of the or other financial interest, do we have consensus then on that third paragraph from our group? Any changes or additions besides that? Okay, not hearing any. I think we can go to the fourth and I believe final paragraph. Pause it. I was wondering if we could scroll down to the consolidated draft recommendation for the fourth paragraph. Please. Is that it? There it is. Thank you. Any discussion from our group on that fourth consolidated draft? Ms. Park?
I had a very quick one, just speaking for our subcommittee. When we looked up in the registered guidelines, where's the closest match with overall sound educational program, we found that it was 5.1, which was part of what we included in our, I'm looking for it right now, but I think it was a guideline 5.1 academic program that touches on sound program. And the thought there, and I've mentioned it before, is just more consistent use of terminology helps in drafting, and it leads to less questions from a reader. Does this particular combination of similar questions really mean the same thing as a reference somewhere else? So that was the only point I had, that 5.1 academic program could be added, and that last section, and it is part of an overall sound educational program because it's duplicative, could be deleted.
And then if I can give one other proposed edit. Right after the beginning, a review of preparation course. For which credit is granted, I think that's our focus. We don't really care if it meets these standards, if it's external.
And
Any
then
other?
just a question, there was some question as to how to refer to the various programs. And here are two different ways within the sentence that differ on what we have above. Do we want to put down that language, the external commercial company?
I think that's a very good catch for that second half, or by, because we want to keep the first half by law school faculty if it's taught in-house. We're changing that to that by an external. Exactly. Yeah, very good catch. And as Dean Parker was saying, the more consistent we can be within the same guideline, the better.
And would the group generally consider it to be the case that it's an external commercial company if, for example, Adapt-A-Bar or fill in the blank, any commercial company is integrated into the curriculum offered a bit each of the 4 years? So an external company offering their program internally at your school would be included within this?
In my interpretation, it would be, because they are an external commercial preparation company.
I ask that because that's a presentation that we're seeing with more and more frequency. So that question will certainly come up.
Dean Park, you have your hand up?
Oh, I think I left it up, but one more term consistency, a review or preparation course. Maybe that could just be a test preparation course instead, because it's echoing what we defined in paragraph 1.
Yeah, very good. Any other further discussion, addition, deletion, changes for paragraph 4 of our consolidated draft? So at that point, Ms. Leonard, I think we have our CSBARS consensus draft of paragraph 1, 2, 3, and 4 now with these additions, deletions, and edits for presentation to the committee.
Thank
Dean
you,
Keller?
Pickford.
Yes, just a quick question. Natalie, I know you had said you would make a note regarding the recommendation of the committee is to have no units limits. Just curious where we think that would fit into the consolidated paragraph by paragraph draft.
My suggestion would be twofold. The first would be to consult with the chair or someone else that you designate as the agenda item is created, and to describe this up front before showing the text at all, and then to double bracket or asterisk inside the text and then repeat the explanatory double bracket or asterisk.
Okay, thanks.
So with that said, is there any further discussion now on the CSBARS consolidated draft as edited together before presentation to the Committee of Bar Examiners? So hearing none, so I think that was our last item on our agenda we were able to discuss today.
That's correct. We'll move the item on the student records to the August agenda. And may I just confirm whether you would like to be the drafting contact, or would you like to delegate it to a member?
I'm more than happy to volunteer unless anyone else would prefer to volunteer in place of me.
We can also have a member team of 2 if you prefer.
Dean Keller, you have your hand up?
I was just noticing my hand was still up. I'm happy. That was not actually volunteering, but I'm happy to help if you would like me to.
Well, only if you want to. I always like to have fun looking for volunteers when I see a hand up. Just
Thank you for being voluntold, Dean Keller.
Just for clarity, the volunteering is for drafting language about the records topic.
Oh, it's actually this topic, the 1.11. The records topic will be delayed for discussion till the August meeting.
Got it. Thank you.
So with
Thank you for
I
that
think
clarification.
Definitely. I think with that we have everything resolved that we can resolve today. Unless, Ms. Leonard, there's something else you'd like us to touch on. I think we can entertain a motion to adjourn. 15 minutes past our time, but again, I thank everyone for volunteering, even beyond their original volunteering, of course.
Thank you,
you,
Chair
everyone.
Frickberg. I'll move to adjourn. But we did a lot of good work today. Thank you for your chairing.
Oh, no, it's always a team effort, and I'm always appreciative when we all work together.
We don't need a specific motion to adjourn.
Oh, I was.
Thank you,
Then we're-
everyone. And thank you for your
then we're-
flexibility today. Appreciate it.